This negligence case considered the meaning of an obvious risk in negligence law under the Civil Liability Act and the role of warnings in relation to such risks. The events took place on Fraser Island in Queensland at Lake Wabi, which has a number of unique features. At its deepest point, it is very deep, down to 12 metres. More importantly, it has a steep sand dune which runs down towards the lake. The sand dune almost begs people to run down the dune at great speed and plunge into the water. Unfortunately, the water adjacent to the sand dunes is not deep water. Mr. Kelly, a tourist in Australia from Ireland, ran down the dunes, lost his balance while running and plunged into the water, striking his head and becoming a partial tetraplegic. Now, to get to Lake Wabi requires a 2.5 kilometre hike along a track. At the start of the track, there is a warning sign which warns people not to run, jump, or dive into the water because it may be shallow. There was a similar sign at the point where the track finally reached the lake. The question for the court was whether the risk of damage from running down the dunes was an obvious risk, and whether the authorities had done all that was necessary simply by providing the warnings. The court found that while there were warnings against running down the dunes, and there were warnings against diving into the water, there was no warning that running down the dunes might result in a person landing in shallow water and severely injuring themselves. The signs made it clear that diving in was very dangerous, but Mr. Kelly had not dived in. He had essentially fallen in. Justice of Appeal Fraser found the message in the pictograms that the real danger was diving into water of uncertain depth. He noted the presence of numerous persons repeatedly running down the sand dune into the lake in apparent safety, and the respondent's own experience in running into the lake without mishap on 9 or 10 occasions. He concluded these circumstances justified the trial judge in finding that the risk of serious injury, which was inherent in the respondent's activity, was not an obvious risk. The result was that to be an obvious risk in Queensland, a risk will have to be truly, blindingly obvious.